Please unmute.
Yeah, last week.
Hello. Hello, can you hear us? They can't.
No.
Yes, sir. Yes, sir. We can hear you.
You
Good morning,
can
sir.
answer me. Otherwise, I would have switched on something else. Is everything okay?
Yes, sir. Perfectly fine, sir. Good morning.
Good morning to you.
So I'm going to make a cup of tea for Mr. Malcolm and a virtual cup of tea for everybody else.
And everybody else can have their cup of tea also.
You had it, sir. Thank you.
Now, I'm not going to touch anything because obviously everything is okay, right? Now, what do we do? Start?
Can we just wait for 5 minutes, sir, and then we can start. Thank you, sir.
Are you okay?
Harsh, can we start?
Sir,
Harsh, there?
we'll start in a minute, sir. Just has some internet issue, sir. We'll start in a minute, sir.
Okay, all right.
You want me there?
I think you'll have to get the UPS because you still not started. Yeah, can you just check the Sridhar? Can you check the battery? I can't see it. It's too bright here. If it has rained too much.
Meghna, are you good to go?
Yeah, we're ready to go.
Yes. Am I audible?
Yes, you are. So can you please start?
Yeah, we can start. We've been ready for the last 15 minutes.
Yes. Thank you, sir. Thank you, sir. Meghna, please go ahead.
Right. A very good morning to one and all present here. I am Meghna Mitra from BLLB Semester 4, and I am the Master of Ceremonies for this webinar. I welcome the guest speaker, respected Mr. Malcolm, along with all the attendees and the members of the teaching faculty today on behalf of the core committee of Xavier Society of Law and Justice. Legalese, as the name suggests, is XSLAJ's maiden event for the year 2022-23. It's an event based on legal drafting. In today's webinar, we have invited an honorary advocate and impaneled arbitrator, Mr. Bapu M. Malcolm, to deliver his address on the skill that legal drafting is, so that the students of Xavier's Law School can get to learn as much as possible about its intricacies and take part in the competition that lies ahead. Before moving forward with today's session, I would like to thank our Honorable Vice Chancellor, Reverend Father Dr. John Felix Raj, for granting us this imminent opportunity. We would also like to thank Professor Pratyusha Das, the Dean of Xavier's Law School, and Professor Animesh Das, the Professor in charge of the Society, and the respective teachers for gracing this webinar with their presence. I would also like to thank every attendee for joining this session, and I hope that through this webinar, you get a fruitful insight into the skill that legal drafting is. Now, for the honorary speaker of the webinar, Mr. Bapu M. Malcolm. He is an advocate and an impaneled arbitrator at the Bombay High Court. Apart from working towards law and order, he's also an Indian Olympic cyclist. Yes, fellow students and respected.
Please. I am not an Olympian. My father was, not I.
But you have 6 matches.
So, I mean, don't praise me where it's not necessary.
Right, sir. Thank you for being so
Not
humble.
an Olympian. My dad was, 1948. Now, please continue. I'm sorry I disturbed you, but I had to.
No, sir, that's all right. So this deserves a round of applause, even on Zoom. And since we are restricted by an online platform, but we are still overpowered with the spirit of respect and admiration. Students, please note that in order to keep the webinar glitch-free, we are requested to send your questions to Harsh Agarwal for the 6th semester, Shaurya Mal for the 4th semester, and Jhalak Agarwal for the 2nd semester. On that note, we welcome you, sir, wholeheartedly to take over today's proceedings and enlighten Xavier's Law School with your address on legal drafting. The floor is all yours, sir.
Yeah. Well, I don't know whether it's good morning or good afternoon. So it's mid-morning, mid-afternoon, or whatever it is. A good day to all of you. It would be nice if somebody, just after I have a couple of sentences, it would be nice if somebody asks one question to get things going. Drafting, as far as I am concerned, is storytelling. Why do we call it drafting and not writing? A draftsman is one who builds up. A draftsman could build up a building, he can build up a factory, he can even build up a circuit. In our case, drafting would be writing. Now, I wanted to be a great writer, very great writer. I studied journalism, etc., etc. But everybody cannot be a great writer. But that does not mean that we cannot be good writers. Good writing would mean a dialogue or maybe even a monologue to some extent. In law, by the way, I'm also a Xavier writer, Xavier School and Xavier's College. So there's a lot of empathy as far as this seminar is concerned. As I was saying, it's a story. You are addressing an audience of one, and that is the judge. Your business is to make the judge believe your story rather than the opposition's. Now, we'll try and divide this into two parts. One is drafting for litigation, and the other one is drafting for transactions, on which, of course, my wife is the expert. She's got 16 years of experience only in drafting transactional work. I have made a few notes. No, this is not a teleprompter. I've got it in my hand, so it will work. To start with, we have an hour to go. And let me be very honest with you. I'll hardly be able to impart anything, and people will hardly be able to absorb because it's too short a time. Drafting was a subject with us, and even through 1 year of college or maybe one semester, it just isn't enough. If you tell me, let's have 50 meetings, I would say good enough. But even sometimes I feel that even 50 meetings would not be, 50 hours would not be enough to get all the nuances of drafting. And the thing is that unless you are up to the mark on everything, anything and everything, it would be impossible for you to produce a perfect document. So we have to believe that we are imperfectionists as far as drafting is concerned. We are going to have problems, but we can minimize them. As I said, I've studied journalism. There are two variations in writing a novel and reporting a story. A novel usually has something very important at the very end. Journalism is the other way around. If you read a newspaper, which of course we hardly get these days because we're in a village and we don't get to touch a newspaper for months. But anyway, a newspaper puts everything in the headline or in the first paragraph. And that is the way it should be as far as drafting for litigation is concerned. Your title must tell the judge what you are going to say. And please do it in the first 2 or 3 paragraphs. Don't keep it as a mystery right up to the end. While I'm at it, I might as well tell you this. I like to keep my briefs brief, 10 pages at the most. Now, of course, with A4, it might go to 11 or 12 pages, but 10 pages at the most. I have received briefs prepared by others which are 80 pages, 100 pages. And in one particular instance, because it was sent to me and I had to read it, I genuinely could not make out whether we were for the plaintiff or Genuinely. I had to return the brief saying that I'm sorry, but I don't understand what it is. Now, if I have all the time in the world and cannot understand the papers in my hand, how is the poor judge going to look at it? They don't have the time, they don't have the energy. And mind you, as one judge very recently famously said, both the parties know the truth. It is the judge who is on trial. So we are putting the judge on trial every day. And we might have to pass 10 orders, 15 orders, 20 orders a day. It is our business to talk not to the judge, but to talk with the judge. Okay, it's a monologue, it's a written word. But anyway, talk with the judge. Explain to him what you want to say in as lucid a manner as possible. Please do not use big words. Unfortunately, English is not the given language for quite a number of in the judiciary. And if you are going to use, thank you, Sridhar. If you are going to use very big words, it may not only not do your job, but it might lead the person who's reading it astray. So keep your language simple. In fact, there is, in engineering, we used to call it the KISS rule. Keep it simple, stupid. And it was the one that won Clinton the presidency when he said, it's the economy, stupid. So we have to understand that we have to keep the matter as simple as possible. There is also what is called the 2080 rule, which I try to follow. And most of the time I do follow it pretty well. 20 words per sentence, 80 words per paragraph. Each paragraph must tell you a certain point. Don't beat around the bush. Don't try to talk about the weather or what you had for lunch that day. What the judge wants is in concise form, the facts, because he is not the one who's looking at, it's your duty to find out the facts and present them to him. In quite a number of cases, don't expect the judge to know the law. They are not supposed, and I repeat it, they are not supposed to know each and every law. It is the business of the lawyers to explain the law to the judge. Many people will argue with me on that point, but I have the greatest of judges in my favor when I say that. And in fact, if you really think of it, if all the judges knew all the laws, we lawyers would be out of business. Why would they need us? So you have to explain to the judge why your story is more important and above all, more importantly, truthful than that of the opposition. You have to explain to the judge why he should rule in your favor. And very importantly, what would go wrong if he did otherwise. This you will find in one of Nani Palkhiwala's books, or maybe a book that is written on him, maybe by Arvind Datar or somebody, which distinctly says that when you draft or when you argue, especially when you argue, but when you go to the Supreme Court and argue, the order is given immediately by the same judges. But we do not have that leisure. We go through the trial for a number of weeks, maybe sometimes a number of years, and the judges change. So you might argue, say X in front of one judge, Y in some, and said in some the other. They do make notes, but I don't think that they are quick enough, or they can be quick enough to jot down everything you say. So the simplest thing to do is to make sure that your drafting has all the points that are necessary. Because the judge who normally writes the order at the end of the day will go through your pleadings, whatever they might be. And again, He won't have a lot of time if the matter is going on for years. So try and make it short, try and make it as brief as possible and to the point. Don't beat around the bush. Don't embellish with unnecessary adjectives or adverbs. Just go to the point. There might be repetition, but make sure that the repetition is only to emphasize and not to tell the judge, look, I'm telling you 10 times, you better listen to me. For emphasis, maybe you might say something and then say too much, which actually emphasizes the sentence before. This will take a bit of time when you draft for litigation, but it is what we learned in advertising. The paragraph, the last sentence of the paragraph must lead to the next. It must make it interesting enough for the judge to read on. It takes a bit of time. In fact, it takes a number of drafts to do that. You might have to juggle your paragraphs here and there to give them in a sequence. But then the sequence is necessary. As I said, it's a story. You are telling the judge your story. Now, when you draft, we'll go back to that. 20 words per sentence, 80 words per paragraph. Means 4 or 5 sentences. The last sentence should be prepared in such a way that it leads to the next. Now, here we come to a conundrum. People will say, don't use italics, don't use capitals, don't use subheadings. I do. And nobody has ever told me not to use it. So in law, I believe that what is not proscribed is prescribed. I use italics, I use bold letters, and nobody has ever, well, how did I learn it? Again, by reading Nani Palkhiwala. I've read almost all his books on him, by him, etc. So don't be scared. Of course, if the judge says don't use italics, don't use bold, next time say sorry, I won't do it again and let it go at that. But till now, nobody. Subheadings are important. I'll tell you why. There's a mass of information that you're giving the judge. He might just want to go through the important things. So a subheading will be important. Now, suppose you want to tell the judge that a certain property belongs to me. You can have a subheading. Suppose you are the plaintiff. Property belongs to the plaintiff. That's about all. This will interest the judge in reading further. When you make a verbatim sentence like that, obviously you have to prove it. Or as a defendant, you say, the property belongs to the defendant. You say how it belongs to you. Now you might ask both the plaintiff and the defendant have the same thing. Normally they won't, but if they do have the same heading, then it depends upon the strength of your evidence, the way you have written your story. Now, as I've told you, first paragraph, there is what I call solicitor language. In fact, I have still preserved one solicitor's power, which my sister in Australia gave me. It's an A4. I think font must be 10. It is less than single spaced. I don't know. There doesn't seem to be any space in between the lines. 2 pages full without a single full stop. Now, if you try to read something like that, you are bound to forget what you started with, what went on in the middle, and what is at the very end. Here, I would like to say something more on the breakup into 3 parts. Every story has an introduction. It has what we call the body. In journalism, we call it the body. It gives you the mass of information. And in the final couple of paragraphs, or maybe a couple of chapters, or maybe the last chapter itself, you give the conclusion. Try and make your drafting in that respect. If you can do that, it will make easy reading. And when it's easy reading, people like to read on. We'll take a couple of questions on this. In the meantime, I'll also look. By the way, I'll show you a couple of books. One is, if you cannot see it, I will repeat it. Practical Guide to Drafting Commercial Contracts. It's by one Bhumesh Verma. Can you see it? Can you see it?
Sir, if you can lift the book a
Yes,
bit up,
sir,
sir, we'll
you
be
have
able to
to
see
lift
it.
it.
Now,
Yes, sir, we can see it now, sir.
can you
Yes,
see
sir.
the title?
So a bit up more if you can, sir.
Yep.
A bit more, sir. Sorry, sir. Yes, sir. Now you can see the title.
Right,
Thank you,
sir,
sir.
it's
See the
visible.
title. And it's a good book as a checklist. It
Noted,
does not necessarily tell you how to draft it, though there are, I'll read out a couple of paragraphs from there to what he talks about, long sentences. I've bookmarked that, I'll read them to you. But the best writer for legal language, nobody can beat this man, Brian Garner. I have yet to read anybody who can beat Brian Garner. American, a lawyer who I think spends most of his not his spare time, most of his life in writing how to write well. Garner on language and writing. Brian Garner, Garner. It's a very expensive book. Sometimes it's not even available because I think it's printed just in America. It's a very expensive book, but you cannot go better than that. In fact, he has written 2 or 3 other books also. We do have them. In fact, we started life as lawyers with one of those books. Fortunately, at that time, there was an Indian edition which was available for some 800 or 900 rupees. Now, I think these books cost over 4,000. They're not printed here. But you can't do better than that. And if 4 or 5 of you get together and buy a book, you can each of you read it. I don't know. During the first lockdown, my wife read the whole book. How long did you take?
It's very readable.
She says it's very readable. Maybe a couple of months.
No, a week.
She says a week. I'm a slow reader, but she obviously has read the whole book in a couple of weeks. I mean, there's some about 700 pages to this. So anyway, we'll come to some paragraphs and some pages in both the books. In the meantime, may I ask for some questions on what we have discussed so far? Would anybody like to do that?
Sure, sir. So we have a question from our convener, Professor Himesh Das. He's asking, what would be the difference, if any, in the approach while one drafts a petition for a trial before a lower court and while one drafts for an appeal before the High or Supreme Court?
Simply put, the trial court is the story. Now it depends on whether you are the appellant or not. Are you the appellant or the respondent? First off, let's say, will Dr. Das tell me whether he wants me to be the appellant or the respondent?
Yes, sir. It's in case of an appellant
Okay.
first and then a
Appellant
respondent.
first.
We would like to hear from the both the sides.
Excuse me while I have a little bit of coffee, please.
Yeah, sure, please, sir.
I'm sure that others are having their coffee too, but they're not on camera. Dr. Das, as the appellant, it's obvious that you have lost in the lower court. Strictly speaking, there are 2 things that you can put into an appeal. One is where the lower, I'm sorry I used the word lower court, it's wrong to use that word. Let us say the primary court. The primary court is the trial court. It has come to a certain conclusion on facts and on law. Strictly speaking, in an appeal, you don't refer to the facts. The facts have been shredded, torn, digested, eaten, whatever it is, and then the trial judge has come to that conclusion. The only thing you can really fight for or hammer is a point of law, or maybe points of law. So if you are an appellant, you will try to tell the appeal court where the trial judge has gone wrong in interpreting the law. There might be quite a number of things you might find. In fact, I'll come to that story a little bit later. Just remind me about the Pune jurisdiction. You might at the later stage find that the court did not have jurisdiction. You're supposed to find it, but there could be some reason why I did not find it. You can challenge it at that point that, look, this trial court did not have jurisdiction. I'm sorry, I did not know about it. I did my level best, but I could not. But now, after the trial court has given its order or its judgment, I find that the court did not have jurisdiction. That would be an excellent point. It would be thrown out. Obviously, the respondent would have to go to another court and fight it out. So this is just one point. Now, as I told you, this is a story which I would like to tell you on this. Recently, we're in a matter in a Pune court. Because of the pandemic, we could hardly go there, appointed somebody else. Things were in a bit of a mess. Finally, the matter came up and we had to go to Pune. And we wanted to find some, we were the respondents in that, we were the defendants. We usually are the defendants. I think it's around 2 o'clock in the morning, my wife, very often she wakes me up at 2 o'clock in the morning with some law or the other. And she told me, she says, I have downloaded the Bear Act for you. Why don't you go through it? And by 4 o'clock, I had found out there was some small clause somewhere which we could challenge on jurisdiction. The thing here was that it was not my duty to check jurisdiction. It was the judge's duty to check jurisdiction. Very rare. I think it must be the only law in that case. Very rare. I'll tell you what it is. The Parsi Matrimonial Act and Divorce. In that, there is one clause, a C clause of 2 or 3 lines, which says that the jurisdiction must be approved by the judge in writing. Only then can the trial proceed. Now, obviously, you can't expect the judge who gets a Parsi matrimonial matter once in his lifetime to have gone through it. But here it said that the judge must put in writing that his court has jurisdiction. We mentioned to the judge, we said, look, we don't expect you to read everything, but will you please open up the book and check it, Parsi matrimonial law. And immediately he said, let the other side reply. This was a small point, but a very important one. So when you are going in appeal, please read the law 10 times and try to find out some mistakes, some flaw, which will help you. There is another way in which you can go in appeal, and that is by finding. Now, this Pune case was both matter of fact and finding. Another way is if you can tell the appellate court that certain points were not found out by you or were still hidden by the respondent. Most people do not believe me when I say this, but it is the duty of the plaintiff and the defendant at the first instance to put everything on the table. If you will go through the CPC and the matter of rogatories, on which we fight many cases on matter of rogatories. Some judges don't even know what the rogatories are. It's unfortunate. Anyway, what you do is you have to put everything on the table. And 9 times out of 10, including, I will admit, even our clients, people want to hide things. Now, if there is an adverse order and you are in appeal, and you find that the other side has hidden some facts, please hammer away on that point, saying that, my lord, the respondent purposely hid this from the trial court, and that is why the order was adverse to me. Please go through it. It might be helpful to you, it may not be helpful. Otherwise, the appellate court might say that, well, it's a very small matter, let it go. But you do have a chance to bring facts and evidence into play, even in the appellate court. The question is it a new matter? Did you try to find it and you were unsuccessful? Was it hidden from you? You can't say I missed it, by the way. You can't say that, well, I went through the papers and I missed it, then the fault is yours. So in that case, you can put in new piece of evidence in your favor. Dr. Das, now shall we go to the respondent?
Yes, sir.
Mr. Dr. Das,
Yes.
was I eloquent enough?
Of course, indeed.
Did I answer your question?
Yes, of course. But the second part is yet to be the
We go to
respondent.
the respondent. Then you can question me on what I missed out.
Of course.
The respondent is obviously the winner in the primary court. The trial court has ruled in his favor. Now, when you appeal, obviously you are going to send your appellate papers, your appeal to the other side. So now if you are the respondent, you will read the appeal and points of law, you will try to demolish them, saying that, no, this is not the point of law, this is not the interpretation, this is the correct interpretation, and the trial court is in my favor. Normally, 80 to 90% of the time, the appeals are dismissed. But if you do fight well, your appeal will be admitted, or it might even be remanded. If you can get your matter remanded, there's a very big advantage. There is no law, there is no ruling against you. You are better prepared, and the possibility is that you will get a new judge who might interpret the law differently from the judge that appealed against you. Getting a remand or a revision is an excellent thing. It's difficult to get it, but if you are a respondent, try and fight it. If you are an appellant, try and get it done. So as a respondent, you will naturally fight it and say that, no, what the trial court has said is correct. The new evidence was in the knowledge of the appellant, and say how you can't make an averment in the air. It was in him. The papers were with him. It was in my original plaint. Maybe he has not had a look at it. By the way, if you are a defendant and you get the plaint, please make sure that you check your plaint with the papers that are given to the judge. It's a dirty tactic that people use. A year back, the judge got in a restoration matter. We had the case dismissed. The other side wanted a restoration. Their restoration petition had maybe 40, 50 pages. I really don't know till now. And we got only 11. Now, why should I get only 11 and the court gets 40 or 50 pages? It was a dirty trick. And we were able to find it out from the weight on the envelope, because it was posted to us. That how can 10 pages weigh so much? So be very careful. Please make sure you are entitled to get it. You can ask for a certified copy of the plaint on day one. I want a certified copy of the plaint. People don't realize that these sort of things happen. But be very careful. Now, as the appellant, if you can prove that the respondent didn't give you all the papers, his case will be thrown out. In fact, if the judge is courageous enough, he will hold it against the respondent and make sure that the respondent cannot move against you in any other forum in the same matter. There are laws to that effect. You cannot fool the court. You cannot play dirty with the court. If you can prove that the other side has played dirty with you, nothing like it. Now here, it can go both ways. The appellant might prove dirty part of the respondent, or the respondent might be able to prove that the appellant is playing dirty. It all depends on how you handle the case. But you will notice from what we have said now, drafting is not just simply writing. Drafting is putting your mind, heart, body, and soul into every word that you put on paper. Normally, I think it like 5-6 times we must be changing drafts. At least 5 or 6 times we go through the drafts. At least 5 or 6 times. If we change one word, we read the whole thing again, because that one word, fortunately, we don't have 100 pages. We have 10 pages to read, because that's what we stick to. One word might change everything from his to her. Then you go right through all the pages and make sure that it is not his or not hers or whatever it is. But drafting is not easy. I have seen people take the plaint and dictate the written statement. You can't do it that way. You have to read the plaint 2 or 3 times. Okay, they've got hundreds of pages. It's a bore. It's torture to go through all that nonsense which they write repetitive all over and over again. But that is your job. You can demolish it by saying that it's repetitive. It has got no meaning on the case. It is unnecessary, etc., etc. But when you draft, you should make sure that the other side does not have a chance to haul you over the coal. Dr. Das, we want to hear from you.
Yes, sir. Just one addition before we move on to what Dr. Samantar has asked, which is also, I think, will be very pertinent for our students to know. Now, suppose we have 3 different stages, one from the court of the first instance to the district court, to the higher court, and to the Supreme Court. Now, in the first appeal, we have gone to the district court, and then for the second appeal, we have gone to the higher court. Please, sir, you can correct me, since I'm not a person from the practical field. I may be wrong in certain technical.
No, there are different ways. Don't worry about it.
Yeah. So, if we are going from the court of the first instance to the district court, and then for the second appeal to the high court, there has to be some difference in approach while we are presenting the petition before the district court and while we are presenting the petition before the higher courts. It could be the high courts or could be the Supreme Court. What are the languages that our students, or even for that matter, anyone who is in the practice, should be looking for, besides looking into the points of laws? Is there any kind of eloquency of language that you would be suggesting?
The language should be lucid. It should be simple. Maybe since you're talking of language, the best thing is to answer in your mother tongue. Unfortunately, there are 100 mother tongues in this country. And the language of did you read about it last week when somebody in Gujarat, in fact, we are right now in Gujarat, we're not in Bombay because the situation there is not very happy, and I'm 80 plus. Somebody in the Gujarat High Court, a litigant, said that Mane Gujarati ma vaat karvi chhe, which means I want the proceedings in Gujarati. The judge, who was from Canada, from Karnataka, who spoke Kannada, he said that the language of the High Court is English. If you want to speak in Gujarati, I will speak in Kannada. Now, if you are an appellate lawyer, or if you are practicing in the other courts other than the primary courts, it is your duty to be perfect in English. If you are not, please ask somebody else to handle your matter. Give them the facts. Even draft it for them so that they can put it into more correct language. But for heaven's sake, if you are not up to the mark in the language, please don't risk it. You will be doing your client a disfavor. And I don't think anybody can be forgiven for that. If we have something in Marathi or Gujarati, we make sure that somebody translates it for us, and we don't try to show off that we understand the language perfectly. It costs a lot to translate papers, but even then we do it. Most of the trial courts, especially in the mofussil areas, do have their proceedings in the local language. Fortunately, these days we find that even in the mofussil courts, English is becoming the norm, and proceedings might be in the local language, but when we plead and say that maybe speak in English, invariably the judge allows us to do it. So the language of the appellate court, the language of any court has to be simple, smooth, as if right now we are speaking with each other. That's the way it should be. You're speaking with the judge. You are giving him an argument which you want him to digest and accept. You're not just having a sort of a speech. It's an empathy that you have to develop with the judge. There again, now we are talking of that, drafting. My very first case, very first case, I think 15 years ago. Friend of mine came and gave me a writ petition in which he was the respondent. We were just out of college and didn't even know what the writ petition was or how to go about it. We were too broke to buy books, or for that matter, a gown. Anyway, somehow or the other, I was not even going to take. I did not even have my son at that time. I was not going to take it. I wanted to do drafting, and I went to court. I didn't know what a court looked like, and this is something which I do even today. If I get the chance, I do it even today. I go and sit in the court where my case is going to come up 2 or 3 days, at least 2 or 3 hours each day, to find out what the judge is really looking for. What are his arguments with the other lawyers? Is he happy with what they are saying? Does he not like what they are saying? Having done that, because as I said, this was my first case, having done that, I realized that the judge, it was in the High Court, the writ petition, a single bench, the judge was using cricketing terms. He used to drop cricketing terms left, right, and center. I went back home, threw out my reply, and put in cricketing terms. We won in 10 minutes without my saying a single word. It was all in my pleadings. The judge could recognize what I was saying because I was using the terms he was happy with, the terms which he used. So it's like friendship, or maybe your girlfriend or your boyfriend. You always try to find out what they like and how you can make them respond to you. It's the same thing with a judge. We may not call it a love affair, but it's at least some sort of an affair. So if you can get the time and go to the court and sit there for a couple of days, find out what the judge wants, and then form your reply accordingly. Nothing like it. I mean, you won't find all this in books, but this is practically what I have learned. Maybe because of 40 years of statesmanship, we we learn to listen to the other side and give them what they want. It might take a bit of time for others, but if you can be on the same page, strike up empathy with the judge, nothing like it. I'm sorry, I've digressed a little bit more than the language that you use, but the words that you use are obviously language. Keep all the frills out. I'll come to that. How much time do we have left?
Sir, we have time now.
How much?
Sir, around half an hour, sir.
Oh, you have half an hour. Acha. Have any more questions on this? There are so many students. Somebody must be having some question or the other.
We have questions from our professors.
Please go ahead. I'm listening.
Okay. So this question is from Professor Prashna Samadar.
I'm sorry. Just a minute. I'm sorry. There's a distinct echo. I can't. Bit slowly,
Okay.
and maybe a little bit soft. Just a little bit softer.
Right, sir. Sir, this question is from
Just 1 minute. Just 1 minute. Just 1 minute. Please do not use that word like. It has crept into the vocabulary of all students, everybody. Everything starts with a like. Please get rid of that word from your vocabulary. Everything cannot start with a like. It only shows that your vocabulary is not enough. You are using that word like to fill in gaps which you cannot. And that word like is now creeping into pleadings. Just as this internet language, I've got it here, where there's a chapter on internet language. Please use simple English. The word like, get rid of it. Get rid of it from your speech. It will be a conscious effort because I know people have been using it for years now. That will go into it is going into pleadings. That word is going into pleadings. What do you mean by like? Either I like something or don't like something. Like is not an adjective. Or like does not explain to you what you want to say. So please, for heaven's sake, I'm sorry I just interrupted you, but this is something you have to get rid of. Okay? Please continue.
Sir, the question is, how much important is the mention of orders, rules, and related laws in a drafted plaint?
Very important. If you can, personally speaking, I don't like precedents. I would like every case, to be honest, merits individually. But the law says that precedents hold sway. In fact, to such an extent that 2 years back, the Supreme Court said that if our precedents are not upheld by the other courts, they would hold the judge in contempt. So obviously, it's very important. At least it's very important to win the case. Whether it's important otherwise or not, I don't know. But it's very important to win the case. And that is where a lot of people are spending a lot of time in research. When I say research means you have to go through so many judgments. To tell you the truth, try to go backwards. Say today we are in 22. Try to go 21, 2019 and look up the latest judgments and try and incorporate them. Don't look up 30, 40 precedents. It doesn't help. In fact, the first case that I lost after 8 years was because my client, who happened to be one of the biggest lawyers, gave me 40 precedents and insisted that I hand over a 100-page argument. No wonder we lost. Who's got the time for all that? In fact, in America, you are only allowed to use 3 precedents. If you want to use more, you have to take permission of the judge. 3 precedents is more than enough. Does that answer your question, Miss?
Sir, if you, with your permission, can I add up to the question?
Yes, please do. It's a dialogue. I don't want it to be a monologue.
Yeah, the question because presently I'm teaching drafting to the students.
Yes.
So
Oh my God, I'm speaking to With a teacher, it's difficult. Huh? You must be.
Absolutely
Please
not,
tell
sir.
me where I'm going wrong. Please tell me.
Absolutely not, sir. You have enormous experience, much more than mine. And I'm really appreciating whatever you're saying. I'm just noting it down, and of course, I'll make sure that I deliver it to my
All that-
students.
All that is copyrighted. You dare not use it without my permission.
Absolutely, sir. I'll take your due permission before using them.
Okay, tell me.
Yeah, what a question generally comes from students' end is that even in our internship days also we have seen this, that in many planes, like supposedly we have to use order 37. Now order 37 is not mentioned just after the title, I mean after mentioning the court in which we are filing the plaint. So
Excuse
will
me,
that,
I'm interrupting. What is order
Yes.
37? I don't remember. I never try to remember this until I look up the book. I might make mistakes. So please, also please, CPC.
It's a summary, sir. It's a summary proceeding, order 37.
Summary,
for
okay,
money
summary.
suits.
So, but
Yeah. For example, we need to mention order 37. For example, it's a plaint under order 37, and we forget to mention it, or if a plaint doesn't make a mention of it just after the name of the court. So how will it affect the plaint, its admissibility before the court? This is a question which comes from the students' end many a time. So I would like you to answer this.
you must have read the papers this morning. This was in the papers this morning.
Yes, it was.
It was right in that 138 case.
Yes, it was. But generally, this comes
I
as
was
a
about
question.
to tell you that, are you talking of CPC or CRPC?
Yes, absolutely true. But the last day, student questioned me the same thing, absolutely the same question. So I thought that nobody better than you can answer this question.
No, I go through, I don't know, maybe 10, 20. Now, of course, it's become easy because InShots gives it to you very easily. But this particular one, in fact, I circulated it to my clients as well as to my colleague because it's a matter of 138 which we are dealing with. And in fact, to one of my colleagues who is not handling these 138 matters, still I sent it to him because it's an important judgment. Anyway, you got your answer in the judgment, so I ask me.
Thank you, sir.
God bless you. What else? If you want to do good drafting, just a minute. If you want to do good drafting, please read. You can't obviously read all the judgments fully, but please also read judgments of other countries. The law may not be applicable to you. It might be that it does not even exist on our statutes. But the arguments in those cases might help you in arguments in yours. Normally, Canadian, American, British, and other, since we follow the Roman system of law, most of us have the same type of laws. But even then, there are some unique arguments. There are really fantastic arguments which are, especially in the American courts, especially in the American courts, you come up with, they come up with excellent words, excellent arguments, unbeatable. It's becoming a big mass though, too much of it. But still, if you want to be a good lawyer, you try to read as much as possible. And every day, 15 or 20 cases you have to go through. Now it's very easily available on the net, 15 or 20 cases, nothing today. Please go through it. And what else?
Sure, sir.
Now we come to, shall we go to transactional drafting?
Yes.
Sitting right next to me is my wife. I'm sure she will correct me every minute because She's into transactional drafting for the last 16 years. And when I need help, I don't have to look further than she. Because she's
Can I be excused, sir?
You tell me.
Yeah, Meghna, there is a question from Jyoti ma'am also. Can you just put it to sir
Yeah,
once?
please do.
Yes, ma'am. Sure, ma'am. Sir, there is a question from Professor Jyoti Chatterjee. Do you prefer to sculpt drafts or knit them?
Please. I find it difficult to understand what you people. I think there's an echo.
Okay, can I just come here, sir?
Yeah.
Yeah. So my question is like, do you
Like.
My question is, do you like to treat your first draft as a sculptor to your clay, carving out a complete figure, and then later you go on to revise and refine, or do you knit elements of your stories together over a course of several drafts? So what is your way? What is the best way of doing it?
I'll tell you my secret. As I said, we are very much into defense rather than claims. In fact, we discourage people from going to court. The first thing, whether you draw, especially if you draw up a plate, you start with the prayers. Don't start with your story. Your prayers are what the judge will reach first. He wants to know what you want. He's not allowed to, and he does not want to go further than that. If you want A, B, and C, he doesn't care whether D is important to you or not. He will only look at A, B, and C. But if you think that you want A, B, C, and D, if you start with your prayers, you won't miss out on it. What we do is, the first thing we do is start with the prayers at the very end. That is our foundation. And then you build up your case. Each and every point that you have put in your prayers, you build on that. It may be a sculpture, as you put it. It was a very nice word to put it, that when you sculpt it. Well, I sculpt the feet. I sculpt the legs. I sculpt the torso. I sculpt the head. I sculpt the hands, and then put them together in a sequence. If you will remember, I said, keep on revising your drafts, especially the paragraphs. Now, if you have got 1 point per paragraph, it's extremely easy to shuffle them around to make a sequence. If you have got 10 points in the paragraph, you won't know where to start and where to end. So I agree. It is like a block of marble which you start to sculpt. But do you sculpt at the feet or do you sculpt at the head? I like to sculpt at the feet. Start with the prayers and then build up your case. On the other hand, if you are in defense, you read the complete plaint. What we do is we make marginal notes in pencil, maybe just a question mark or an exclamation mark or no, yes, something like that. What we agree with, what we do not agree with. Maybe one line in the margin for something important, 2 for something more important, 3 for something most important of all. That allows us to get rid of the chaff. We concentrate on the wheat, because that 1 line, 2 lines, 3 lines will tell you that there was a lot of, and invariably plains are repetitive. Invariably, 9 out of 10 plains are repetitive. I think, I don't know whether they charge per page or not, but I think clients like big briefs. The word in itself is an oxymoron, a big brief, but clients like that. मैंने 500 पाना का पेज court को सब समझाया. Court doesn't have the time to listen to all that. I mean, you're wasting your time, wasting your client's money. So if your paragraphs, each paragraph is mentions one particular point, don't make it repetitive unless it's absolutely necessary, or later on you might say, please refer to paragraph number so and so where I have said this, and this is in continuation of that. But you sculpt it in such a way sculpt it with the, at least we sculpt it with the feet first. And in the defense, we make these points. Each point we try to destroy, unless of course it's beneficial to us and we agree with it. Each point we try to destroy. Then club them together. That in paragraphs 22, 107 and 314. It's the same thing. So we club them together. It takes time. It's a difficult job. We club them together and say this paragraph, is repetitive, and that is why you want this. Another thing which you brought up right now in a plaint, and the word like. There is another word which I personally hate, and that is the word that. I don't know why everybody starts a paragraph with that and a comma. I really don't understand why it's done. That and a comma, that and a comma. Why? It makes reading so difficult. Please try and read a plaint like that, or a written statement like that. You know, something starting that comma, that. The moment you get a comma, you stop reading for maybe a fraction of a second. It's not at all necessary. And in fact, my wife would bear me out. Signed, sealed, and delivered. Now, what does signed, sealed, and delivered mean? If there is a document, I have to sign it. If I sign it, it has to be sealed, which means either attested or physically sealed, and delivered because the other side wants the document with my signature. So what does it mean, signed, sealed, and delivered? In fact, I've got some pages over here which don't have 3 words, but 4. Maybe now we'll even come up with 5. It's not necessary. 1 word will do. I have executed the document. It means I've signed it. It means it is been sealed, if necessary, and I've given it to the other side. I'm not going to hold on to it because the other side wants it. So I can easily say I've executed it. So try and don't use these cliches, for heaven's sake. They are outdated. They are a nuisance. Make your pleadings very lucid. Make it easy to read, easy to understand, and above all, easy to remember. Does that answer your question, Lily?
Yes, sir. Thank you so much. And the usage of that is, I'm grateful to you that you said that, because that
comma.
That
no,
comma
said
has
that
to be
comma.
stopped. That has to be
You said that
clearly.
Today.
Yeah, starting from today, it has to stop. Thank you so much, sir.
Another thing that is commonly repeated, I don't know why they do it. The plaintiff states and submits. Every paragraph starts with that. The plaintiff states and submits. The plaintiff states and submits. 100 times the plaintiff states and submits. Why can't you have it at the heading? The plaintiff states and submits. So and so, so and so, so and so. I mean, the number of words that you are adding, the nuisance that you are creating, it becomes difficult to read. I don't know, maybe they're trying to impress the client by making it so mystical that the client is very happy. Nahi, har baar likha. States and submit, बहुत अच्छा advocate है, हर बार वही लिखा. I mean, it makes no sense. The modern pleadings that you read all over the world, we are still stuck in that archaic solicitor language, which does not make any sense anymore. People don't have the time to read all that, and it's a nuisance to read it. So make your pleadings, your drafting as lucid as possible, as if you are speaking with each other. Why do you want to use unnecessary words? Lot of people like to use fancy words, big words, most of which they may not even understand themselves, and it might give the wrong meaning to the judge. Be very careful of that. Don't use words that you don't understand. Okay, now next. Is there any further question?
Yes, sir. There are questions.
Please do. Please go ahead.
Yes, sir. This question is from Ms. Devabhya Chittaraj. Respected sir, with respect to criminal law, my question is that is it advisable to include witness statements or evidence to the legal draft to be presented in a court of law? If yes, sir, does that include evidence pertaining to the matter of privileged communication?
What was the last word? Matter relating to?
A matter pertaining to privileged communication.
Before I go to that, I believe that there are, if you've seen some photograph of mine in some place, I've put this. Justice, equity, common sense, which is common law, frivolous litigation, and malicious prosecution. Each and every case will fall within these 5 points. If it is frivolous litigation, please point it out. 70% of matters that go to court are frivolous litigations. I can assure you of that. 70% are frivolous. They should not be entertained. The person must be fined heavily for that sort of nonsense. The courts don't have the time. We get overloaded because 70% are useless cases. They should not even stand the light of day. So frivolous litigation is out. Now, in a criminal case, you would have malicious prosecution. Now, if you are the complainant, please understand that malicious prosecution is against the law. You should be put in jail for that. You cannot harass people. Courts are not meant to harass people. I know clients will come to you and say, I will give you all the money you want. And you say, but it's not a good case. I don't care. I want to harass that. Is this what courts are meant for? Is this what lawyers will pick it up because they get money? But is this what we are meant for? Are we meant for frivolous litigation or worse, still malicious prosecution? You might hang a man because you lied. And there have been so many cases where people have not only been convicted, but executed because somebody wanted to and somebody bore a grudge against that person. So please, for heaven's sake, avoid it. If you find that the other side, the complainant, if you are in the defense and the complainant is insisting on malicious prosecution, please hammer on that point. Unfortunately, even if you get the case against the accused dismissed, the law against the person who has indulged in malicious prosecution is very weak. You have to take the permission of the Attorney General or the Advocate General, and only then can you prosecute that person, which I think is wrong. If you find a person lying in court and in a criminal matter, you might go to jail, your whole life might be destroyed. You don't have to be convicted. Your name comes in the papers that such and such a person has done such. Your life gets destroyed. Especially for women. If some nonsense comes into the papers, she's got to bear that for the rest of her life. So please make sure that there is no malicious, frivolous litigation, okay, civil matter, but malicious prosecution. Throw your client out if he wants to do something like that. If you are in the defense, please hammer it to the judge that this is malicious, please throw it out. Now, the first part of your question, will you please repeat that?
Yes, sir. The first part was with respect to criminal law. My question is it advisable to include witness statements or evidence to the legal draft presented in a court of law? If yes, sir, does that include evidence pertaining to the matter of privileged communication?
Okay. Now, normal in a civil matter, how would you proceed? As a complainant, because if it's a private complaint, how would you proceed? You would complain to the police station. 9 times out of 10, unless something changes hands, police are not going to take any action on it. Your complaint should be good enough that when you go before the magistrate forces the police to investigate. They might come up with a C summary, that is a different thing altogether. But it will force the police to investigate. There have been a couple of cases recently where the police has been hauled up either for not taking any action or taking the wrong action. I'm glad it's coming up, but it seems to be with every policeman in every police station. It seems to be the norm rather than the exception. So in your complaint, make it, I know they tell you in CPC that you need not put everything on paper in your plaint. I think it is wrong. Why can't you put everything in your plaint or in your complaint? What's wrong in doing that? You're not playing poker where you hold the cards close to your chest and not let the other person see it until it's necessary. What is wrong in putting everything in front of? In fact, this morning when I was going through the book and triple words, I thought of one thing. It's in the book. Ready, willing, and able. It means the same thing. Ready, willing, and able. It means the same thing, but it looks nice. And there was a song which says, ready, willing, and able. Put your cards on the table. It's a love song. You have to put your cards on the table. Why are you worried? Why are you scared? The law now the law does not allow you to spring surprises on the other party. Yet, you are allowed not to put everything in the plaint. Maybe you are not allowed to put, or they ask you not to put everything in the plaint for the reason that some plaints can be so useless that they can be thrown out without taking them to trial. And that's a rarity. How many cases have you heard of where the judges have thrown them out at the first instance on day one, saying that your plaint is meaningless, I want to throw it out? Have you ever heard? I have never heard of a case like that. Have you heard of it? Has anybody heard of it? So I see no reason why you should put everything on the table on day one. But in your in a crime matter, I think it is absolutely necessary because police are not going to take any action. Usually they don't, let me put it that way. You will definitely come across some good guy or some decent jam, but maybe they are overburdened and they don't want to do it. They feel that everything is frivolous. I don't know. But if it is my case, I would like them to investigate. Others get the magistrate, and then the magistrate asks them to investigate. He has to get the whole story. The complainant has to be before him. The complainant has to expand on the complaint. The complainant is actually cross-examined before it goes to the police for investigation. So it's better that you put everything into your complaint. Don't make it into 500 pages. But as I said, make it into a nice, likable story with the first paragraph saying what you wanted to say. First 1 or 2 paragraphs saying what you wanted to say. Have I answered that question?
Yes, sir. Thank you, sir.
What else?
So due to time constraints, we cannot ask more questions.
Okay.
But you were talking about transcriptional drafting.
Yes.
So you can continue with that.
Yes, I will ask my wife to join me because she's the expert on that. Transactional drafting, as I see it, and as it is being done today, is voluminous. It says so many things without really saying anything. Just in the last 2 days, my wife and I have been having an argument on how it should be drafted. I believe that it's time to change. Transactional drafting should also be almost like a story. Now, what we are right now, we were discussing for a leave and license agreement. All these years, we have been sort of almost copying from the books because there is so much of information available on that. And adjusting it slightly to the needs of the moment. I still felt that those 10 pages, 15 pages is not really necessary. And that it can be shortened without use of unnecessary words, coming to the point directly. I feel that transactional matters should be done that way. I don't know, Sweetheart, do you agree with me? Then that was thumbs up, but I don't think she'll be able to get out of it after 15 years of doing normal drafting. But give me one reason why transactional drafting should be so voluminous, so complicated. Is there any, can anybody tell me why? Give me one reason why it should be so much. Why should a power of attorney go into 14, 15 pages and ask him to do this, do that, do this? I feel, genuinely, I have always felt that people make this so big, so heavy to carry, literally so heavy to carry, because they are not sure of themselves. They want to put in as much as possible to cover all the bases. I might have forgotten this, put this in. That one, let's put that in. Let's put this in. Let us not get caught. If you are expert at your job, you won't feel that you're going to get caught or that you will left out something. You have to be good at it. And if you're good at it, naturally you will condense it. So, in fact, there are associations, there are organizations which help you concise, make your matter concise. Yesterday, there was one which said from 99 words, they came to 33. And it made sense because the 99 words to read was difficult. It was a pain. So there are people on the net, you will find it, simple English, plain English. You'll find people who are, in fact, now it's become a business. So if you find that your transactional document is very big, or even if you don't find it very big, it might be a better idea to get it vetted by one of these people so that they can make it. In school, we had it, I don't know, I'm talking of 54 and 55, 56 maybe. When in our, what was called the composition class at that moment, we had subjects like grammar and composition. It was called the Pressy writing, where we had to reduce a story or even a paragraph to 1/3 or less. And today it is standing me in good stead. 1/3 or less of what you write initially. So in transactional documents, why not give bullet points in transactional documents? Why do you have to start every sentence with a that, this, and this, and this? Is it necessary? So my feeling is that transactional documents, those big books, deeds and documents, they're that big, you can use them for weightlifting. Read those. Copy them down if you want on your computer and start condensing them. Leave out everything that is frivolous, what is repetitive, what is really unnecessary, and finish it off. If it's a general power of attorney, not specific, why do you need 14 pages? Everything that I would do, I allow my power holder to do, and I will ratify it. Everything in law, which is within law, which has reference to this particular matter, I'm allowing them to do it, and I will ratify whatever they do. Isn't that enough? Instead of writing that they will open bank account, they will close bank account, they will put checks in, they will withdraw money, they will go to an advocate, they will go to a counsel, they will take permission for. I mean, unless you are sure, if you say everything in toto, can anybody, in fact, if you say everything in toto, even if you have forgotten anything, the other side, if it points it out, you can say, well, I've said in toto, I've said everything. That means what you are saying also. When you write too much, you might forget something. So as far as transactional work is concerned, I think there is a definite need for a rethink. And if you look into Garner's book, the one that I showed you, he's got chapters on that, of how you should condense things. Please, it will be an effort, but at the end of the day, as I told you, that 2-page power of attorney, which I got from Australia 40 years back. one sentence of maybe five, I don't know, maybe 1,500, 2,000 words, one sentence. Does it make sense? And so and so. Another thing, starting with a preposition, and. If you can avoid it, avoid it. But if you can't, please go ahead and use it. Chaucer, who used to write, I don't know, about 600-800 years back, used to start sentences with an and or a but. We use however or moreover. It may not be necessary to use that word. So don't feel shy of using the word and or but. And we were taught that in school, that you should not start with that, with an and or a but. But I think now we've come over that and it makes for easier reading. If you go through the book, give me another couple of minutes. I will read. I will tell you the edition and the pages on which you will find this. And the books make wonderful reading. I'm telling you, you won't be able to. Divya honestly said it took her less than a couple of weeks. They are fluid to read. They flow like a fast-moving river with the wind hitting you in the face, fresh wind into you. So these books are worth reading. So I'll read out those pages to you if you want. You can get your paper and pencil and note down those pages. And if you get your hands on the book, maybe they'll be available in the library. Just look them up. There's so much of information. It's impossible for us to do it. As I said, even in 50 seminars, we won't be able to do it. But a few of them, I have got it. So I'll read out the pages to you. Okay. What else? Sweta, just 1 minute. I'm asking my. What else would you like me to discuss in transactional matters? I have demolished your theory completely. What would you like me to talk to them about?
Read the law, don't have clauses which are against the law. Like
Yeah. As Divya says, transactional documents doesn't mean that you just write a document. It's as good as litigation as far as the law is concerned. Please read the law perfectly. In fact, this is what we normally do. As soon as we get the case, we buy a Bare Act. Doesn't cost much. Because there are changes from time to time. And we buy the latest Bare Act. And if it's not a very big one, I suggest go through it. It's a matter of revision. But you will find 1 or 2 points which are extremely relevant to the document that you are going to make. As Divya recently, just now she mentioned it, there are big solicitors who put arbitration clauses into things like leave and license and rent act matters. It's against the law. It won't hold good. If somebody points it out, you'll literally look like a fool for having drafted such a stupid document. So be very careful. Please read the law. And if you have doubts, I look at arbitration this way. Any matter in arbitration between 2 parties, the results of which are not applicable in rem, only then arbitration. Now, arbitration in a rent act matter. If a judge passes if a judge says that go in for arbitration, that means everybody else is going for arbitration. And what is the arbitrator going to give? He cannot give a judgment on that because that judgment would be held in all the cases. So what happens is if it's between 2, this is a very rough rule. If it's between 2 parties only where it will not affect anybody else, arbitration is good. Like I like to do sports arbitration. Now suppose I have a matter of, usually these in sports it's matter of doping. I have a matter of doping. And in the arbitration, I give the award to either side. It doesn't mean that that award can be used as a precedent in other cases. It cannot be because you'll have to prove that case separately. So the rough rule is if it is applicable in rem, that means to everybody, no arbitration. If it is applicable to everybody, if it is applicable to, if it can be applicable to everybody, no arbitration. If it is applicable only to a couple of parties, 2 or 3, go in for arbitration. So it's a very important thing. Please don't put these sort of clauses into your transactional work. Would you in transactional work refer to precedents? Peter, would you refer to precedents in transactional work? Come closer so that they can listen. Okay. In transactional work, I would not use precedents, but I would refer to something that would make sense. Like I said about arbitration, if somebody insists on it, I would do that. But otherwise, read up the basic law and try to include that in your document. Transactional documents, also make them as short as possible. Make sure that all the points are in. If they're not in, as I said, give it a global view. But here again, at least read it 2 or 3 times. And if possible, get them vetted. Get them vetted by a third party. They might be able to point out quite a number of things. It might cost you a little bit, but get them vetted. Alternatively, if you are on good terms with the other side, both of you prepare documents and try to merge them. That's a very simple way of doing it. It's sort of sitting across the table and saying, well, I've got this, you got that. We agree on these points. Let us put it down on paper and get it over and done with. That's exactly what we are doing yesterday. The other side, we said, we'll send you our document. You go through it. If you have something to say about it, send it back to us immediately, whatever you have, and let's get going in. So in the next 3 or 4 days, that document will be over and done with. Both parties are happy. Matter is over. Now come, tell me what else.
Sir, due to time constraints, we are supposed to end the session now. So thank you so much for giving us an insight into the skill that legal drafting is. And thank you for correcting our mistakes, both small and big. We are looking forward to the competition that lies ahead. I'm sure that the students of Xavier's Law School have learned a lot from you, and they will remember this till and after they have become advocates. So
the fact
so
is
much.
that I learn a lot from students because students are listening to one person. I listen to a dozen. So I get more information and more education than you people do. Every question that is asked of me is a new question, and I learn a lot more. So don't think that I'm teaching you. In effect, you are teaching me. I'm learning. In fact, as the Dalai Lama said, if you say something, you are repeating what you know. If you listen, you are educating yourself further. So that's why I want you to ask questions. It helps me a lot. Anyway, if you got just a couple of minutes, I'll tell you what I was talking about, since I've marked it and taken a bit of effort on it. First of all, this is the book by Brian Garner. The edition is in fact, the forward is by Ruth Bader Ginsburg, who was a Supreme Court judge. She passed away very recently. I think one of the first women to do it. The first 2 or 3 pages are excellent because they tell you what you should do and what you should not do. But anyway, I'll go to the bookmark pages. One of them is keeping a daily diary. And another thing that my wife has underlined, the 5 keys to moving towards competence are these. And I'll only read the last one to you. To be self-critical as you can stand being, but no more. When you draft, you be self-critical. That is most important. And that is on page 26. Page 27 is for keeping a diary, but I don't think that is very important. I wish everybody could, but it's almost impossible to do these days. So note down page 26. Page 57, judges on effective writing. This is what judges are trying to tell you. I'll read out a couple of them. Lawyers spend a great deal of their time shoveling smoke. Do you know what shoveling means? It is taking a shovel and taking earth from one side and putting on the other, or taking coal and putting it into the furnace. You pick something up and put it somewhere else. Now this judge says that lawyers spend a lot of time shoveling smoke. Can you shovel smoke? You can't. So what he's trying to say is they're wasting their time doing nothing. Too many lawyers believe that it is essential that legal English, that one write as pompously as possible. That we've said, don't write pompously. So that particular chapter on page 57 is an excellent one. It helps a lot. Page 63 on conjunctions and sentence starters. And but it's been going on for years. Don't feel shy about using it. Please go ahead and use it if it makes sense and if it makes for easy writing, easy for the judge to understand. Please do that. That was page. I'm sorry, I did not give you the page on that. That was page 63. Then we come much later, page 314. Able and willing, act and deed, aid and abet. It's almost the same thing. Even three words. Three words are triplets. Cancel, annul, and set aside. They're all the same. If you say I cancel it, it means that you have annulled it, you have set it aside. Or this one. Remiss, release, and forward discharge. What does it mean? I don't understand it, and neither will the judge. It just looks very pompous. So please don't use it. And there are even longer ones than 3 words. There are 4 words too. So try and avoid all this. Just one word, which is a specific word which you want to convey. Please do that. Then that was on page 314. 315 is an excellent one. In the very first paragraph, he says defendant generally denies each the allegation. Generally denies every allegation. Generally denies all the allegations. Defendant generally denies singular allegations. The third line, defendant generally denies all the allegations, is good enough. In fact, I would not even use the word generally. I would say defendant denies all the allegations. Full stop. Unfortunately, the CPC now asks us to deny each and every allegation pairwise, but the same sentence can be used for every paragraph. Then go to page 484. It's called the blue book, the maroon book, and some other book. They've given it colors and names because of colors, which the American Law Association brings out once in a while so that people can follow it. But I think the last one, this ALWD, which stands for the American Lawyers Association, that seems to be what is on record now. And there's another thing on puns and smelling of the inkhorn, which is on page 519. These are big pompous words which you should avoid. Last one is interneties, which I had referred to. Dialogue of the web tribe. Please avoid it. Please use English as English should be spoken. Don't use. In fact, when I was teaching at a college, very often I used to get it in my answer papers. A B and a 4. It's meant to be before. How long does it take you to write before instead of writing B and 4, especially when you type it? Just give me 2 minutes more. I'll give you something fantastic on this. I had to take 2 orders to a court. The client that morning sends me an SMS. She says, remind 4 orders. 4 as a numeral. Remind 4 orders. I knew I had to take 2 to court. I spent whole morning trying to find the other 2. I wanted to ring her up and ask her what she meant, but she was at the fire temple and switched off her phone. Finally, I realized that the letter at the numeral 4 meant FOR, for. Remind 4 the orders. Now, can you imagine how much I mean, you could hang a man for want of a comma. So please don't use these fancy things. And finally, she tells me, you don't know computer language. I said, yes, I don't know computer language. I know just plain English. Please use it. And I have told my students that if ever I find something like this, because B and C, COZ, no, I want the full word because. Why should you use it? Or using short terms. I mean, there are a million short terms these days. Can't really understand what you are saying. I must be on the same page as you. In fact, one of the shortest terms which I learned many, many years ago, 50, 60 years ago, was SLR. It stood for single lens reflex in a camera. I found that the letters SLR meant savings and loan ratio, small luggage rake, snow-laden runway. There are 103 meanings to that SLR. And you literally might hang a person by making a mistake. So please, if you want to write single lens reflex, write single lens reflex, put it into brackets so that in future SLR would mean that only and nothing else. So when you draft, especially when you're drafting transactional documents, in the first time 3 or 4 words appear and you want to shorten them, please do that. So that in like licensor or licensee or lesser and lessee, you can use names. There is no harm in using names. It makes it a lot easier to understand. So I think with that we'll call it a day. I hope I have been as useful to you people as you have been
sir.
with me.
Absolutely.
And maybe we meet another time and talk of other things. May I know I think second and third year students, aren't you?
Yes,
The
sir.
first year as well. So all three.
How many of you are there today? I
So
really
near
can't
to
see this.
300, sir. 300 names.
Wow, 300 people and 3 questions asked. Oh my God. I'm sure that everybody, out of those 300, at least 290 have gone for a cup of tea, left their computer, left laptops on or the telephones.
So there were many questions asked, sir, but due to the time constraint, we're so sorry, sir.
I'm so glad if there are 300 people. I'm happy if 300 people are really there. I'm happy. I hope I've been able to contribute to 300 people. I know I have broken rules which have been set for years. I know I've been rebellious in some respects, but I sincerely believe that that is the way to win. I have not lost the case because of drafting. Never. From case 1 till today, it is my drafting that has stood me in good. Forget what you babble in court. You might say 100 things in court, make a lot of noise, impress your clients or impress the crowd. It is your drafting that wins the day. And please make sure that your drafting reaches the judges. In 2 cases, we have found that quietly our pleadings were removed from the papers, and the judge pronounced the order without reading them. We had to go back to court and get it rectified. There are times when your good pleadings might be quietly removed when the judge is dictating the order. Be very careful of that. It's a criminal matter, but a lot of people use it. Best thing to do is to have pagination. Each and every one is. I'll tell you what they normally do. They take your first page and number it. Don't number the other pages. And the judge only reads your first page with a few points on it and nothing else. So be careful of that also. And these are tricks of the trade which you will come across once or twice in your lifetime, but be careful.
Can you find out? I think Mr. Malcolm is disconnected.
Yes, sir. His laptop battery got discharged, I think. He warned us of it.
Because I think, wait, madam, if you're there.
Yes, sir.
Madam, should we wait for a couple of minutes and just check? Otherwise, it will look really bad.
Yes, yes, sir. You can just check. So if they can, the students can check with sir, and if he is available, and he can contact once more.
Yeah, of course. Harsh, please get onto it.
Yes, sir.
So we can ask the students to join the respective classes.
Madam, it's totally your discretion. You can definitely do that.
If they're
We'll
not
just wait for.
Yeah, we'll wait for
we'll
sir,
just-
but it's not required for all to wait in that case. So the teachers and the students who want to join the classes may leave the meeting, because already sir is not able to see everyone. So I hope if they want to join the classes, they may leave now.
Yeah, but ma'am, with your due permission, can I add on to something?
Yes, yes.
Yeah, ma'am, because drafting was necessarily for the 6th semester students. So I would appreciate that sir come and ends the session, then we can join for the class.
Yeah, you can leave. The drafting students may be waiting, but the others may leave, sir, ma'am.
Yeah, sure, ma'am.
So Malcolm sir is here.
Yeah, I think he's joined.
Both of them. I think. Can I hold it in my hand? Am I visible?
Yes, sir, you are.
Yes, sir, you're visible.
Acha, fair enough. I'm sorry that the laptop ran out of battery power. It only goes to show that an 80-year-old man can outrun modern equipment. Maybe I spoke so much that the laptop gave up on me. Anyway, we were about to end the matter. I thank all of you. I mean, the 300 participants. I'm very happy that so many people, and especially because it's St. Xavier's. It's my school and my college. So, shall we call it a day now?
Sure, sir. Thank you. Thank you very much, sir, for joining us.
God bless you. If there's anything more that I can do, please let me know. Okay?
Yes,
sir.
Thank you. Thank you very much.
Thank you, sir.
Thank you so much, sir.
My pleasure. Don't thank me. My pleasure. Okay? Bye.
Bye, sir.
Bye,
Have a
sir.
nice day.
Have a nice day. So we have covered everything on the checklist for today, which brings us to the end of this session. Now I would like to call Umang Agarwal to deliver the vote of thanks.
A very good afternoon to our valued and worthy guests, honorary speaker, respected teachers, and beloved friends. It is of utmost honor to me to be presenting this vote of thanks to the webinar. I, on behalf of the core committee of XSLAJ, first of all, spread my most sincere thanks to the guest speaker for the day, Mr. B.M. Malcolm. It's been a very learning experience. I want to thank Honorable Father Vice Chancellor for trusting us with this wonderful opportunity. I want to thank our teachers present, Professor Prashna Samaddar and Professor Jyoti Chatterjee, for adorning the necessary work and gracing us with their presence. Further, a big thanks to the professor in charge of XSLAJ, Dr. Animesh Das, for his constant guidance in all our endeavors. I'd also like to express my heartfelt appreciation to Mr. Molai sir and German sir from the IT office, for without their support, the smooth functioning of the webinar, both on YouTube and Zoom, wouldn't have been possible. I would like to place my hearty thanks to all the dedicated and well-motivated members of the core committee of XSLAJ who worked tirelessly to give our maiden event for this year a successful start. It has been a pronounced pleasure. Lastly, I want to thank all my batchmates and seniors present for their cooperation in this webinar. You all have been a great audience. Thank you for all your questions. Now, I'd like to ask the convener of XSLAJ, Professor Animesh Das, to bring today's proceedings to a fruitful end with a few words.
Thank you, Umang. I had not waste much time because it's already time for our next class. So it was a lovely organization from your end, and we all are looking forward towards the competition. So I think by the first of next week, almost all the students will get a brief about the competition. And yes, this was really good. Thank you all. Thanks to our coordinator, Madam Dr. Pratusha Das, for helping us with all the things and for approving the entire program. Thank you very much, all of you. And let's get back to the class now.
Thank you, sir.
Thank you, sir.
Thank you, sir.
I recorded those items.
Mr. Malcolm, sir.
I'm trying to switch off.
No issues, sir. Just wanted to thank you, sir, especially
Yeah,
for
yeah.
enlightening us all, sir, about the skill, and especially for conducting the webinar in your garden, sir. It was a good start to our pleasant morning, sir. To hear the chirping of the birds.
It's not our garden. We are only managing it.
So that's all the same, sir.
And
Thank you to Mrs. Malcolm for her support as well, sir. Thank you, sir.
God bless you. Vita, Zoom पर करूँ क्या? Or shall I just switch off the phone and start it again? That will be the easiest thing to do.
So we'll spare you the trouble, sir. I think if Harsh Bhaiya can just help you with it, Harsh Bhaiya.
I should work. Yeah.
So there should be a leave button on your screen.
Yeah, I think
sir has left.
Okay.
Okay, we end this.
Yeah.
Okay, bye.